Madam Chairman, my name is Jim Cooney. I'm speaking on behalf of the North Carolina Association of Defense Attorneys, and I'll do my best as a trial lawyer to keep it under 5 minutes. On behalf of the North Carolina Association of Defense Attorneys, we're going to limit our comments solely to the reporting of malpractice settlements, and specifically, and for the record, we object to the rule as it's presently proposed. I'm going to confine my comments to the retroactive application of the rule. There are other people here who will be addressing the prospective application. I leave that to the policy and to the evidence that the Commission gathers. But the retroactive application is particularly bothersome. It is bothersome for this precise reason. Physicians, over the last 7 years, have entered into settlements throughout this state under confidentiality clauses. They have done so anticipating that those settlements will be confidential. Plaintiffs have many times insisted on confidentiality clauses because a confidentiality clause protects not only the physician, but it also protects the injured party, particularly where the injured party is a minor or an incompetent or a person who may not be used to dealing with large sums of money. Protecting their identity, protecting the resolution of that case as a payment is important to them, and in fact far more important to them than it necessarily is to the physician. What this rule will do is give anyone with a computer and a mouse 2 mouse clicks to go from a report of a settlement to exactly what the case was. It's not going to be difficult. And in that process, you're going to breach the confidentiality of many of the settlement agreements and, frankly, a lot of the court orders that have been issued placing this under seal. It's clear to me, as I review the constitutional law on this and the proposed rules, that this impairs the obligations of the contracts that physicians entered into on settlements. Physicians were not provided any notice that despite an agreement that things would be confidential, a state agency, under the color of law, would later and retroactively try to breach that contract, which is precisely what this rule proposes. Now, as I take a look at the recommendations of the Federation of State Boards, they contain no such recommendation. In fact, this proposed rule goes well beyond what the Federation recommends. As I take a look at the other states that have enacted this, there are only a small number of states overall in this country who have made their rules retroactive. There's only been a single challenge that I've been able to find in New Jersey, and the New Jersey court went off on the grounds that all reports to its medical board fell under the New Jersey Public Records Act. There has been no litigation that I can find that has challenged this kind of rule yet under the contract clause of the Constitution. Plainly, what you seek to do is state action. Plainly, what you seek to do with a retroactive application will change the agreements entered into between injured parties and physicians and their insurance companies for settlement. You will be changing the contracts retroactively. That violates the contract clause of the Constitution, and in my judgment is unlawful, and also the judgment of the North Carolina Association of Defense Attorneys. Whatever you do prospectively, as a matter of policy, you cannot do this retrospectively. And we strongly urge you to reconsider the retrospective application of this rule and ask you to consider the lawfulness and whether or not this is legal, and to
4 minutes.
Thank you. And to seek and accept opinions from the Attorney General's office on the application of the contract clause to this action you're about to take. I'll be happy to answer any questions in the minute or so I have left.
Any questions?
What is your understanding of the recommendation of the Federation of State Medical?
The recommendation of the Federation of State Medical Boards first was not to report every malpractice settlement. It was only to report 3 malpractice settlements within a 10-year period. So this goes well beyond that. I could not tell from the recommendations whether they were recommending it retroactively or prospectively, and they seem to be silent on that issue. But there's a threshold requirement from the American Federation, and they certainly don't advocate a retrospective look that comes anywhere close to what this proposed rule has. Because, and remember, we're not talking about judgments.
5 minutes.
Judgments are public records. Nobody's arguing with not reporting judgments. It's simply a question of reporting confidential settlement agreements retrospectively for 7 years.
Thank you.